Okay, ma'am, can you tell me your name, please?
Sharice Bank.
Okay, 1 second. I've got one other case before we take your matter, so I'm just going to put you back in the waiting room for a minute.
Okay, thank you.
Okay, let's see. Counsel, which case are you guys signing in on?
Hello, Your Honor. Gary Popovich. I'm here for Jesse Short for the parent versus Short matter.
Okay, thank you. And Mr. Glazer?
Good afternoon, Your Honor. I'm here on the Kalkaska Memorial Health Center, Munson Medical et al. V. Faribaugh.
Okay, that's the 145. Okay, thank you. I'm just going to put you back on hold for a moment.
No problem.
All right, and Mr. Popovets will go on the record in that case. Parent versus Short, file number 2514932. I do not see anybody for plaintiff's counsel. Have you had any contacts with plaintiff's counsel at all?
Yes, Your Honor. We've spoken, and just in an effort to be fully transparent, there was an earlier status conference in this case that I appeared late to, and the case had already been called. And Mr. Bransky, the plaintiff's counsel, was extremely courteous in that regard. So I appreciate that, and I don't know what the confusion is as to his lack of attendance today, but we've been communicating by email. We've worked with a selected mediator. Again, in transparency, we didn't notify the court in time, so the court picked a mediator, but we've had it's Mr. Carey out of Grayling, and we've had communication with him regarding scheduling. And in fact, my office just submitted to you a proposed order extending deadlines for which Mr. Bransky and I have both agreed to, and he's authorized me to sign with permission. So that was mailed, I think, yesterday, because we realized that very little discovery had been done. We were now pressed against a mediation deadline. So we've extended those dates and submitted that to Your Honor. And probably by the next status conference, I would assume, or next scheduled hearing, we'll be a lot farther along and would have completed mediation as well.
Okay, did that stipulation include a date for a next status conference in it?
No, it did not. We did not coordinate with the clerk upon the proposal. It's just the extent of those other deadlines. If you'd like me to take the lead and communicate with him and then loop the court clerk in to then advise as to that, so it's a full circle or a global resolution as to the scheduling, I'm happy to do that, or we'll just get a notice from you as to the next one based on those deadlines, whichever is easiest for Your Honor and the clerk.
Yeah, so how far is the extension? How long?
May bear with me for just a moment, Your Honor. I'll pull up a copy of that document.
Yeah.
We've extended the mediation 90 days out to September 1st. Discovery shall be completed by 90 days, extended 90 days out to which is August 2nd for discovery. And then, and then the settlement conference currently scheduled for June 2nd shall be adjourned and rescheduled 90 days out. So I apologize, Your Honor. The order hasn't been entered, so I, of course, wanted to be here. Maybe that's also part of the confusion with Mr. Baranski, is that he was expecting this to go out from our office earlier, and it didn't. But I'll represent. So we did address the adjournment of this conference for 90 days. So it'd be subject to the clerk's review and then rescheduling, I suppose.
Okay. All right, that makes sense. So then I'll just indicate for our order today that we'll proceed based on the stipulation of the parties extending dates. And yeah, I mean, it sounds like he probably assumed that that would have gotten signed and this would have come down in time. So that's all right. So we'll proceed further based on that order. The court will send out a notice of the date and time for that next status conference in 90 days, and we'll go from there. Is there anything else we can address today?
No, Your Honor. Thank you. Nice to see you and have a great afternoon.
Thanks, you as well.
All right, take care.
Do we have any in person this afternoon?
Police.
I don't think we have any hearings in person, so if you want to lock the court, we cover. Just,
Yeah, I just wanted to make sure nobody showed up for you.
yeah, no, I appreciate it, but I like to, if we don't have anything in person, I like to just lock the doors. We don't have people just wandering in and out.
Chuck today's got some stuff going next door and I'll.
All right.
help with that
Oh.
one.
Oh, never mind.
That
Yeah,
one, the only one I seen was,
Bison.
okay, they're all good? All right.
Bison.
Okay, sounds good.
Thank you. We'll go on the record in Schlitt versus Furlough. This is file number 2514862. And based on my review of the file, it looks like that case has settled. The parties did submit an order that the court signed dismissing that action. So nothing to do on that one. And we'll go on the record in West versus Spink. This is file number 2314111. The record should reflect that Ms. Spink has appeared in this case. However, I don't see any of the either the lawyers, Ms. Spink, have not appeared. So I think what we're going to have to do is reschedule this hearing. I'm not sure why neither of the attorneys have appeared. We sent out notice of them. But we're not going to be able to do anything today without them present. So, did you have any questions about that?
No, they emailed me twice to remind me, so I'm not sure why my attorney hasn't appeared either.
Okay. All right. Well, I appreciate you being timely and being present, and we'll send out another notice, and you'll get that in the mail, and you're free to disconnect at this time.
Okay, thank you.
Okay, Mr. Glazer will go on the record now in Kalkaska Memorial versus Faribault. This is file number 2615028. The record should reflect that counsel for Kalkaska, Mr. Glazer, is present by Zoom video. This hearing was set for 1:45. It's now 1:51 by my clock, and Mr. Faribault has not appeared. This is set for a hearing today on plaintiff's motion for summary disposition. Mr. Glazer, I did have an opportunity to review that motion as well as the brief supporting that. Was there anything you wanted to state for the record today in support of that motion?
I'll keep it very brief, Your Honor. Just for the reasons stated in the motion, I'd also like to add that the defendant has failed to respond to this motion for summary disposition, which was factually supported through documentary evidence that under 2.116G4, the defendant cannot rest upon his mere allegations or denials of his answer, but had to come with documentary evidence to create a genuine issue of material fact. So for that reason, the defendant's failure to appear and the reasons stated forth in plaintiff's brief and motion, we would request the motion get granted and judgment entered today in the amount of $26,844.93.
Okay, having reviewed the motion and the file generally, and I do agree with counsel's statements, the court is not in receipt of any written response by Mr. Faribault. So I think from a procedural standpoint, the plaintiffs are entitled to summary disposition based on the failure to answer. But I think, even from a substantive standpoint, the plaintiff has certainly produced appropriate documentation of the debt. I think in previous hearings, and I don't believe Mr. Faribault has ever denied that he received services or ever incurred the debt. So I think even from a substantive standpoint, the plaintiffs would be entitled to summary disposition. So the court will grant the motion for those reasons as well as the reasons stated in the motion in brief. I will sign the civil judgment. Mr. Glazer, I would just request though, because there was a motion, that you follow this hearing with an order granting the motion for summary disposition for the reasons stated on the record and submit that under the 7-day rule.
No problem.
Yeah, just in case there's an issue later, dispose of the motion. And then I will sign the judgment here. With today's date, is there anything else I can address for your side today?
Not at this time, Your Honor. I thank you for your time today.
Okay, thank you, and you are free to disconnect.
Have a great rest of your day.
Thank you. Okay, ma'am, on the Google Pixel 7 Pro, can you tell me your name?
Rochelle Osborne.
Miss Osborne, okay. I'm gonna call your case in just a second, Miss Osborne, so I'm just gonna put you back on hold for just a minute.
Okay.
And then Miss Watson. You're Amanda Watson, is that correct?
Yes, sir.
Okay. All right, we'll go on record in Watson versus Smith. This is file number 2615034. The record should reflect that Miss Watson is present today by video. And this is set for a default judgment of divorce today. And so, Miss Watson, did you want to proceed with the divorce?
Yes, sir.
Okay. I'm going to place you under oath, and then I've got some questions that I need to ask you. The questions I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Watson, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No.
Under this divorce action, you would not be receiving any alimony or spousal support. Do you understand that you would be waiving that forever and would not be able to come back later and ask the court for that?
Yes.
And have you and Mr. Smith divided up all assets and debts of the marriage?
Yes.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Watson. Court will grant the divorce. So, Ms. Watson, there's one final step that you need to take before the divorce is final. And there's a form called a judgment of divorce. And that's the last form that the court has to sign to finalize your divorce. So you'll need to get a copy of that form, and you can get that the same place you got your other documents to file for divorce. You'll need to fill that out and submit that to the clerk's office. And that's a very important step for you to follow because you're still not divorced until you do that and I sign that judgment, okay?
Okay. Is that the piece of paper that sort of looks like a marriage certificate? Or what you would fill out to get a marriage license?
No, that's a different form. This one will say right at the top, judgment of divorce.
I think I already submitted that to to the clerk.
Yeah, I looked in the file that has not been submitted yet.
Okay.
So again, that's a very important step because until you do that and until I sign it, your divorce will not be final.
Okay.
Okay? Do you have any other questions?
No, I do not.
Okay, thank you. You're free to disconnect at this time.
All right. Thank you.
See the Tobias one, please.
So judgment.
Okay. Okay, Mr. Osborne, are you able to hear me okay?
Yes, Your Honor, I can hear you.
Okay, and we have Miss Osborne connected now, so we'll go on the record in Osborne versus Osborne. This is file number 2615041. The record should reflect that both parties are present today by Zoom video. I have this as a date to enter a judgment of divorce in this case. And Mr. Osborne, is that how you wanted to proceed?
Yes, Your Honor.
Ms. Osborne, is that how you want to proceed as well?
Yes, Your Honor.
Okay, so I'm going to place you both under oath. I've got some questions that I'm going to be asking each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both please raise your right hands. Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. You can both lower your hands. Mr. Osborne, as the party filing for divorce, I'll be asking you questions first. Mr. Osborne, you filed a complaint for divorce and you signed that complaint. Is that true?
Yes, Your Honor.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, I have been.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, Your Honor.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed that complaint?
Yes, it was, Your Honor.
Does that remain true today?
Yes, it does, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, there are not.
Under this judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, I do.
And have you and Miss Osborne divided up all assets and debts of the marriage?
Yes, we've been talking about things to just divide upon us. Yes,
Okay. Have you reached agreements on those things?
I do believe we have.
Okay. Do you own any real estate or real property together?
The house that we're both in today.
Okay. How is that going to be handled?
Well, I'm going to stay in the house. My wife has already bought another house, so I'm going to give her some money, and I'm going to stay here.
Okay, so I have to, in this judgment, I have to put down the specifics of how this is going to work. And so I got to make sure that there's agreements on all things before I can divorce the two of you. So is there any debt associated with that house?
Are you talking to me, Your Honor?
Yes.
Yes, I'm still paying for the house.
Are you both on the mortgage?
I pay the mortgage. We're both on the deed.
Okay, but she's not listed on the debt. She's not listed on the mortgage.
Correct.
Okay. And how much are you going to give her for her?
I'm gonna give her $10,000 now. I'm gonna give her $10,000 in 3 years when a investment matures, and I'm gonna give her $10,000 more in 5 years from today when a different investment matures. So there'll be a total of $30,000 I'll be giving her, and she can take anything from the house if she wants. It's anything that's here is ours, and she's welcome to anything.
Okay. All right. Miss Osborne, is that your understanding of how this is going to work as well?
That is correct, sir.
Okay. And are you going to sign a quitclaim deed over to Mr. Osborne?
Yes, if that's what he wants me to sign, yes.
Okay, because you'll continue to be, an owner of that property on the deed until that's signed over to Mr. Osborne. So that's something that the two of you are going to need to agree on whether that's going to
Okay.
happen after you've been paid the full 30,000 or whether that's going to happen right away. So have you talked about that?
We've talked about aspects of that, but haven't agreed on a time frame.
Okay.
I think.
Well, again, the difficult thing is here, I can't grant a divorce for the two of you until we have all these, these terms are set because it makes a big difference to whether you're going to sign over your interest in the house to him now or in 5 years after you're paid the full amount. Do you understand what I'm saying?
I do. I think that we would agree then that it would be, I would sign off after the 5-year payment. Does that
Okay,
sound okay with you, Toby?
That sounds fine with me.
Okay.
Okay. All right, I think that's reasonable. What I'm going to put in then is that you'll sign over the quitclaim deed at that 5-year mark or when you've been paid the $30,000 in case, if he pays you that sooner for whatever reason, then I think it would be fair for you to sign over once you've received all the money. Would you agree with that?
Yes, sir.
Okay, so just give me a second to write this in here. Can you tell me the address of that residence?
It's 1887 Plum Valley Road, Northeast, Mansalona, Michigan, 49659.
Wait, what's going on?
Just Scott asks, it's here for the 3.
Tell him he needs to sign in. He always does this. He shows up when it's scheduled by Zoom.
So I told him, I thought it was by Zoom. He goes, yeah, I'm just here.
Yeah, no, I'm tired of these guys just deciding whether they're going to show up or not. Okay, please, thank you.
Tell him to wait.
Tell him he needs to sign in on Zoom.
Okay, thanks, Doug.
Okay. I'm sorry, folks. I had an issue come up here that had nothing to do with you guys.
Okay,
No
thank you.
problems.
Okay, so I'm going to read what I've put in here and make sure that it's acceptable to both of you. So the plaintiff, Mr. Osborne, is to pay the defendant a total of $30,000 for her equity in the marital home at 1887 Plum Valley Road Northeast, Mansalona, Michigan. Plaintiff shall pay $10,000 at the time of the divorce, an additional $10,000 3 years from the date of the divorce, and $10,000 in 5 years from the date of divorce. Defendant will sign quitclaim deed upon payment of the full $30,000. Mr. Osborne, is that agreeable to you?
Yes, sir.
Ms. Osborne, is that agreeable to you?
Yes, sir.
Okay. Uh, So that's all the questions I had for Mr. Osborne. Ms. Osborne, I have a few additional questions for you. Did you hear all the questions that I asked Mr. Osborne?
I did.
Did you hear all of his answers?
I did.
Do you have any reason to believe that any of the answers he gave were untrue?
No, I do not.
And are you currently pregnant?
I am not.
That's one of those questions I'm required to ask by statute. So, are you asking to have your last name changed?
I am not.
Okay. All right. So the court finds that the statutory grounds for divorce have been met by the testimony of the parties. I will grant the divorce, and I've signed that judgment of divorce with today's date. So your divorce is final as of today. If either of you would like a copy of that judgment for your records, you can contact the clerk's office here in Kalkaska. Mr. Osborne, did you have any questions at all?
No, sir, I don't.
Ms. Osborne, did you have any questions?
Oh, thank you.
Okay. All right, thank you. That's all for this hearing today, and you're both free to disconnect at this time.
Thank you.
Thank you.
Okay, looks like we have everybody connected, so we'll go on the record in Nellis versus Munson Healthcare. This is file number 2113787. If I could have counsel put your appearances on, please.
John Elliott, Your Honor, on behalf of Mr. Nellis.
Good afternoon, Your Honor. Jim Elliott, also on behalf of Mr. Nellis.
And Your Honor, good afternoon. Kevin Lesperance on behalf of the defendants.
Okay, we're on the record today. Plaintiffs have filed a motion for attorney fees and costs as a discovery sanction based on MCR 2.313C2. I did receive the briefs of the parties, and for both sides, I had a chance to review those along with the attachments. Mr. Elliott, whichever one of you would like to address any oral argument you might have on this motion today.
Thank you, Your Honor. Again, I will be brief. These sanctions are not discretionary if certain factors are met, and I believe they are as set forth in the motion. So I'll basically just address a few factual distinctions I think are relevant based on the response that I received. First, and I don't really know how necessary this is, but these discovery were not sent during a time that the court limited discovery to the issue of immunity. The court had done so for 90 days starting July of 2022 and ending October 14th of 2022. These were sent in November of 2022. and they were answered on December 13th, 2022. Discovery was not limited at that time to the issue of immunity. Even if it had been, there was clearly a duty to supplement, but it had not been. And Your Honor actually entered an order compelling discovery on or after a hearing on January 4th, 2022. Then in February of 2022, Your Honor again at that time imposed limitation on discovery to the issue of immunity. But during that period of time, it was open discovery that these were served and answered. Even if it was not, again, supplementation would have been needed. But even looking at the first two orders in Defendant's Exhibit 1, it's clearly revealed that during this period of time, there was no limit on the discovery. And Your Honor actually entered another order compelling discovery during that period of time that you later held in abeyance at that time, indicating that the matter was going to, or at that time, you were limiting the discovery to immunity issue. These facts, though, as set forth in the motion, these are not legal arguments. These are factual assertions that we requested the defendants admit to that would have saved hundreds of hours of litigation. Essentially, the crux of this case, was defendant injured? Was he under the two individual defendants' controls? Which clearly he was. Discovery and trial has revealed they were the only ones there, the only ones who had them. And Your Honor even dismissed Mr. Aylesworth because he was completely under the other two individual defendants' control. They denied this. They didn't say we don't know. They didn't say we need medical records. They didn't say anything else. They didn't need that because they were there, and these are factual assertions. They knew he was injured. They wrote a report. It came out at trial that there was a report written that we didn't get to see because it was claimed as peer review. But it came out at trial that they did write a report. They knew he was hurt. They knew he was breathing fastly, and they knew he was in such pain that he had to be transferred back to the other hospital. But they denied that. I'd like to address the cases just briefly because the defendant cited a few cases. The first was, two of them are for the proposition that somehow a party can deny something for 5 years of litigation and right before trial say serve some sort of limited admission of certain aspects of the case, legal admissions of partial liability, and say they get out of any possible sanctions. If so, the sanctions would have no bite whatsoever, would have no purpose. The first was Midwest Bus Corp versus Department of Treasury. In that case, the parties settled the matter. They settled the issue that it was actually a legal issue, a legal request to admit. They settled it voluntarily and mutually. Then the matter was dismissed on other grounds. It never went to trial on anything, and it did not involve one party unilaterally deciding to make a limited admission to try to change the rules. The other case was King versus Michigan State Police. Again, same thing. This thing was a legal issue. It had nothing to do with any sort of factual assertion. It was a legal argument over whether or not somebody had standing in the case, and the court ruled it was moot. It was not any sort of factual assertion that had to be proved either through trial or through the course of the case. The last case that the defense relied upon that I pulled up was Richardson versus Ryder Truck. In this one, it seemed like they were relying upon it for a different reason, but essentially that was a completely legal assertion that they asked the defendant to admit that you were negligent, and the defendant wouldn't admit to that. That's not what we have here. These were factual assertions. Did you safely transport someone across the parking lot? No, you didn't. They knew they didn't do it. They knew he fell. They knew he fell over. It's not some sort of legal argument. It's not some sort of legal assertion. It's did it happen? Was he injured? They did not give a straight, they gave a denial. They said, I deny that he was injured in the way that plaintiff said, and didn't say anything else. If they do not specify that, it's a denial. They denied that he was injured. This is what we spent the next 5 years of this case fighting over and proving. It was never a given until the very end when this limited admission liability came in. It was never a given that he was injured and they were accepting liability for it. They fought that every step of the way here. That was something that came up 25 days before trial. The last thing I just want to touch briefly on is the hourly rate. The defense does not get into a big argument about the hourly rate, but essentially say because it's a contingency fee, the hourly rate would be different. They never say what the hourly rate should be. They don't address whatsoever the factors, the Purgu factors that are generally looked at there, and they don't address the economics of law and practice that's put out by the State Bar of Michigan every few years. That's been, and I cited in our brief the case law that confirms that is something that can be relied upon in terms of determining a reasonableness of an attorney's rate. Even in this case alone, the hourly rate that suggested $500 an hour is less than the recovery that was had was. If they wanted to use the actual contingency rate, it would be higher than the $500 an hour for these number of hours. So I would suggest that, and I don't think the defense vigorously argued that anyways, but I do believe sanctions are appropriate here, and I would ask that you grant them as requested in our motion.
Thank you, Mr. Lesperance.
Thank you, Your Honor. Well, we obviously would request that the motion be denied. We do not feel that sanctions are appropriate here. We view their motion as an invitation to dig into the weeds of the requests, the proofs at trial, and their billing, because essentially they've alleged or asserted that all of their billing to things that are completely unrelated are to be charged as sanctions. But our position is that you don't even get there for a number of reasons. First of all, they listed 5 requests for admission, and I'm going to go through each of them individually. None of them contained denials of information that they subsequently had to go on to trial and prove, and that's key. They did not prove any of these propositions at trial. Almost all of them were covered by the admission that we made in November of 2025. And the idea that it would have to be something at trial is the one case that he didn't talk about that's in our brief, and that's Radke versus Miller Canfield. That's a Michigan Supreme Court case 453 Mich 413, and it's a 1996 case. They have cited no authority whatsoever, and certainly no authority that the law in Michigan is that you can get requests for admission sanctions based on a subsequent admission of liability. And they have cited no authority, and there is no authority that you can get requests for admission sanctions in Michigan on facts that you didn't prove at trial. So they are looking, and at trial is the key, I believe. There 2 of the requests for admissions that they reference, 26 and 27, have to do with safety. And the evidence and argument about safety, the safety of the transport, whether it was negligent, was covered by the admission that was made prior to trial. They never had to prove that it was safe or done not safely. That was admitted in advance. And in fact, Your Honor ruled on a number of occasions that information about that particular topic was irrelevant. It rightfully so ruled. Request for admission number 6, whether this was a scheduled transfer, that was not an issue at the trial. And I believe that there were competing testimonies between my clients as to whether they knew before they got there or whether they drove to the hospital, to Munson Medical Center, to drop somebody off, and then just were then told that there was someone that they could take back to Kalkaska. But The point for your analysis today, I believe, is that that is not any issue that was of consequence in the case. Similarly, they cite request for admission 21, whether Mr. Nellis was under the exclusive control. That's also just not an issue that was even tried in this case. That has to do with the res ipsa claim that Your Honor dismissed many years ago. And that leads us to request for admission 20. In response to request for admission 20, on whether the Mr. Nellis was injured, they made a number of different characterizations or claims as to how Mr. Nellis was injured. So we denied as untrue that Mr. Nellis was injured in the way and to the extent alleged by plaintiffs. That's a position that we took at trial, and that's a position that we won on trial, not them. Everything that was not covered by the limited admission of liability, we prevailed on. We admitted that there was liability for the two gentlemen working on the cart, Mr. Bryan and Mr. Miller. We did not admit liability with respect to Mr. Aylesworth, and then at trial, we prevailed, not them, on that claim. We got directed verdict. And with respect to the injuries, they alleged all sorts of different things. They alleged that he fell down, he got physical injuries, he broke ribs, he got a pneumothorax. We admitted those things. Then they went on to claim more, that the fall caused him to suffer and ultimately sustain a worse outcome of his stroke. And that was something that was contested at the trial, and we won, not them. They did not prove that. So for all of those reasons, because they didn't prove any of these things at trial, because these things were not of consequence, and because they were covered by the admission of liability that we did have and the admission of certain damages that we admitted prior to trial, they did not have to prove those at trial. We would ask that the motion be denied and that Your Honor would sign Exhibit 5 to our response brief, which denies their motion and closes the case once and for all. Thank you.
All right, thank you, Mr. Elliott. Anything in response?
Your Honor, most was already covered. The only thing I would address is the argument that the damages issue was completely prevailed in the defendant's favor at trial. Another major part of this was not just 6 broken ribs and pneumothorax. It was also the delay in reaching the point where he got, and both Dr. Raja and Dr. Gebel agreed that my client was, at the very least, delayed. Dr. Raja said maybe up to the point of trial. There's no way, I don't think, to know whether or not the jurors found that, but I would anticipate, because, again, defendants' own employees and their expert acknowledged that he suffered that damage, that there was clearly damage in addition to what was accounted for in their limited admission liability. But again, my position is that, and I believe the law speaks for itself, that is not enough their limited admission liability is not enough to curtail the power of the sanctions. But that's it.
All right, thank you. So again, I did have an opportunity to review the briefs of the parties. I do want to just go through the applicable law here, which is MCR 2.313 C2, failure to admit, and that is where a party denies the genuineness of a document or the truth of the matter as requested under a request for admissions under 2.312. And if the party requesting the admission later proves the genuineness of the document or the truth of the matter, the requesting party may move for an order requiring the other party to pay the expenses incurred in making that proof, including attorney fees. The court shall enter that order unless there are one of 4 exceptions, one or more of 4 exceptions. Number 1, the request was objected to and that was upheld. The admission sought was of no substantial importance. The party failing to admit had reasonable ground to believe that he or she might prevail on the matter, or there was other good reason for the failure to admit. And so that's the standard that the court is applying. And so along with the exceptions, again, the other party has to prove that matter at trial in this case. So looking at the request to admit, plain and simple, when I read through them, I agree with the defendants in this case. And I disagree with the statement that had they answered these different, it would have saved hundreds of hours and 5 years of litigation. I just think that's patently incorrect. And if we look at, as an example of that request to admit that plaintiff Edward Nellis was injured. Well, if the defendants admit that, which I guess theoretically they could have, but that is such a broad request for an admission. And I think the way the defendants answered that was absolutely correct. And that is, this case wasn't about whether or not Mr. Nellis was injured. It was about the nature and extent of that injury. And in particular, to what extent it may have affected his stroke and the recovery from his stroke. So the answer to that question of whether or not he was injured, that really does nothing to add anything to the case or resolve anything about the case. And when it's posed so broadly like that, I think it's completely reasonable for a defendant to say, well, we can't really answer that because of the way that the plaintiffs have alleged the nature and extent of those injuries. And so it's not as simple as whether he was injured. And I suspect that, if the defendants had made that admission, then the plaintiffs, would have, because it was so broad, would have attempted to extrapolate that into something else. And so I think, out of an exercise of prudence, and again, I think perfectly reasonably, the defendants couldn't answer that question as it was posed. I think if the plaintiffs had phrased it as admit that plaintiff Edward Nellis suffered, 6 broken ribs, a pneumothorax, and a flailed chest by being dropped from the stretcher, that's a completely different issue. And I think that puts the defendants in a position where they can't really deny that. And that maybe is more useful information that saves some proofs at trial and saves some litigation. But again, admit that he was injured, a yes or no question to that broad of a statement doesn't do anything to save any kind of litigation, in my view. So as an example, and I think all the requests to admit are like that. They're in that nature, or they're in the nature of information that was of no substantial importance to the claims and to the jury's determination in this case. And I think plaintiffs presented a lot of evidence of things at trial that were admitted to by the defendants in their admission of liability. And so to the extent they chose to do that, that's fine. But I don't think they can present evidence in support of a proposition that's already been admitted to and then claim that somehow a request to admit that was issued 3 years before gives them the ability to ask for attorney fees for entering proofs on a topic that they didn't need to prove anymore. So for all those reasons, I don't find that the requirements under C2 are met. And I think that either sub B or sub D applies for the reasons I've stated. So the court is going to deny the motion. I think a stickier problem, Mr. Lesperance, and the way that I would handle from a procedural standpoint is if you can prepare an order that reflects the ruling of the court today, I don't know whether or not it's appropriate to enter it as a final order that closes the case at this time. So I'd like you to submit that under the 7-day rule with that language. And if the plaintiffs object to that, then we might need to have a hearing as to whether that's appropriate as a final order that closes the case and begins running the timelines for appeal. So I'll just ask you to present that order under the 7-day rule.
Thank you, Your Honor. We will do that.
Your Honor, if we stipulate to that language, and I can talk to John Elliott about it, if we let Mr. Lesperance know today, then could we just do it by way of a stipulation?
Yeah, absolutely. If you get word that there's a stipulation as to form of that order that he submitted, I'm more than happy to sign it. I didn't know if you guys would agree to it or not, or whether you wanted a chance to consider it, so.
Thank you, Your Honor.
Okay,
Thank you.
all right,
Thank you, Your Honor. Gentlemen, just let me know.
We will, Kevin.
Okay, thanks,
Okay.
guys. It's nice to see you again.
You
Bye.
too.
thank you. Feel free to disconnect all parties on this case. Thank you.
Okay, thanks, Jeff.
Okay, looks like we have the parties connected, so we'll go on the record in Austin versus Austin. This is file number 2615018, and we have both parties connected by Zoom video. I have this set as a scheduling conference in this divorce case. However, I did see that there's a proposed consent judgment of divorce in here. So I guess, Mr. Austin, I'm going to ask you to address that for me. Have you guys agreed on all of those things? And do you want to move forward with entering that judgment today?
Yes, we have agreed on that, and yes, I'd like to move forward with that.
Okay. Miss Austin, do you agree with that as well?
Yes, I do.
Okay. Okay, so I'm going to place both of you under oath. I'm going to ask each of you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both please raise your right hands. Do you both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hands. And Mr. Austin, my questions are going to start with you as the party who is the filing party. You filed for divorce in this case and you signed that filing. Is that correct, Mr. Austin?
That is correct.
Okay. And at the time that you filed that, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And had you been a resident of Kalkaska County for at least 10 days?
Yes.
In that request for a divorce, there's a statement that indicates that there's been a breakdown in your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed that claim?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
And let me see. And I have in front of me a proposed judgment of divorce that you signed back on January 23rd of 2026. Do you recall signing that judgment?
Yes.
And prior to signing that, did you read and understand all the terms of that judgment?
Yes.
And by signing that, does that indicate your agreement to abide by all those terms and conditions?
Yes.
Okay. All right. Thank you. Miss Austin, have you heard all the questions that I asked Mr. Austin?
I have.
Did you hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No, but I would like to ask for clarification on the wording of your question regarding children.
Yeah, I
Okay.
think I made a mistake there.
Okay.
Are you asking, did we have children during our marriage?
No, I'm only asking whether there are any children that were born to you who are still under the age of 18.
Oh, still under the, okay, thank you for clarifying. Then he answered correctly. The answer is
Okay.
no.
So you had children, but they're all older than 18.
Correct.
Okay. All right. Are you currently pregnant?
I am not.
All right. Again, I'm looking at this judgment of divorce that you signed also on January 23rd of 2026. Before you signed that, did you read and understand all the terms of that judgment?
Yes, I did.
And by signing that, does that evidence your intent to abide by all those terms and conditions?
Yes.
Okay. All right, thank you. So the court finds that the statutory grounds for divorce have been met by the testimony of the parties. I have reviewed that judgment of divorce. I find that it's generally equitable and contains all the provisions required by law. I've signed the judgment as well as the uniform spousal support order that's part of that judgment. That means that as of today, your divorce is final. I did not see in there, and it may be in there and I just missed it, but Miss Austin, are you asking to have your last name changed?
Not at this time.
Okay. All right. Mr. Austin, do you have any questions for me?
No, I do not.
Miss Austin, do you have any questions?
No, I do not.
Okay. So if either of you would like a copy of this judgment for your records, you can contact the clerk's office here in Kalkaska and they can get a copy for you. Otherwise, that's all for this hearing today, and you're both free to disconnect at this time.
Okay, thank you so much.
Thank you, Your Honor.
Thank you. Okay, can we get to that next one, please?
Zig, what I should have said.
Before we go on to that, can you look in this one and see? I didn't see notice of hearing. I want to see if Jen has set a date. Or maybe
For the bench trial?
yeah.
Oh, yep, it's right here.
Oh, it is.
That's okay.
Scoot in a little bit if you would. Can you get in there?
Yeah.
Okay, Mr. Alves, are you able to hear me okay?
I am, Your Honor. I have Miss Hayes sitting next to me. She does not have Zoom, so we're going to do this sitting side by side.
Okay, so we'll go on the record. In this case, it's file number 2514997. Both parties are present by Zoom video. And we do have, based on our last hearing, the court set this for a half a day bench trial, which is scheduled for July 14th. And then I believe that this is on today because Ms. Hayes, you filed a motion. Is that correct?
No, Your Honor, I filed the motion in limine. To outline it, Your Honor, Ms. Hayes' grandparents placed her and themselves on a deed for two different pieces of property, two different legal descriptions on one deed. And there's, certainly some discussion as to, let's call them lot one with a house and lot two with a pole barn. There may be some disagreement about how all the paperwork and everything that went down, but eventually my client sued Ms. Hayes in 2015 for a deed to lot two with the pole barn on it. And Ms. Hayes took the paperwork to her attorney. He did not file a response in a timely fashion. She was defaulted. She hired another set of attorneys. They came in an attempt to set aside the default. And of course, that's a two-prong analysis. Is there good cause? And then do you have a meritorious defense? And the law is clear that the fact that your attorney failed to file an answer in a timely fashion is not good cause. And therefore, the default was not set aside, and that property was then deeded to my client. I brought a motion in limine for the trial to state that those issues have been resolved, and therefore they would not be relevant to this case. As you and I know, because it's been resolved legally, that the term would be moot. I didn't put that into my motion simply because Ms. Hayes is not represented by an attorney. I wanted to keep it as simple as possible. So what I'm trying to do is limit what we're going to be talking about on the 14th to streamline that case by saying lot number 2 is resolved legally, it's done. And let's just discuss what is relevant to lot number 1.
Okay. All right. And Ms. Hayes, what's your position on that?
I disagree, Your Honor. I disagree with partial 2 should be entered in. For the simple fact, it was on one deed, both pieces of property. I did not sell the plaintiff the property for $6,500. The deed was split. And when I took the deed through probate on April 7th through Judge Boudet, it came back 2 deeds. Well, my grandpa was deceased at the time. My grandpa could not have come in and put an address on a piece of pole barn property. My grandfather could have not 5 days later come in, pull permits in the plaintiff and his wife's name, using my grandparents as the owners, and they're the contractors. Now, the land contract was done in 2012, but my grandparents were alive in 2013. When on the paperwork, they were both deceased in 2010.
So tell me what do you think happened in 2015 with this default?
This default, I hired Kipley. He took it over probate, to get my grandparents removed. He went after the Lamars to repossess my property. Then after a little while, Mr. Kipley turned on me and he did not answer the default. He let me go in default intentionally so they could get that piece of property. I fired Mr. Kipley, which we know what happened to him afterwards. Hired another attorney to fight the default. And unfortunately, that did not result in that. But on the paperwork, there was no paperwork, Your Honor, created on April 1st of 2012. That's why the paperwork looks shady. I mean, if you look at it and said it was dated 2 years prior, 2 years later, signing it, 11 months later notarized, and a year later recorded, no, the documents were changed.
Let me ask you this, Ms. Hayes. As part of this case right now, are you asking me to change something about what happened with that default?
I'm asking you to I'm asking you, as far, Your Honor, is allowing partial 2 as part of evidence in the trial because it was never sold.
Okay.
It was split off deceptive schemes, Your Honor.
Okay. All right. So, when a default judgment's entered, and if it's not set aside, then that becomes, something that can't be changed. So I cannot reopen or relook at anything that was decided as part of that default. So to the extent that you're going to ask me to change what happened with that default or make a decision that's different than what was decided by that default, or make decisions about facts that were decided as part of that default, then from a legal standpoint, I just can't do that. I mean, that's something that we call res judicata. It's something that's been decided. It wasn't overturned. Nobody appealed it. And so now I can't just take a second look at that and decide I want to do something different about it later. So to the extent that you would be trying to provide evidence or ask me to change anything about that, then I would agree with Mr. Isles that from a legal perspective, that's not something I can reopen or change at this point. That's something that's set in stone. So I don't know exactly how the proofs are going to come in, Mr. Isles. And some of that is, and I appreciate the motion in limine, certainly, but sometimes, it depends on how it's presented, and there may be some of those facts that are relevant to the current claim. But as a general proposition, I cannot, make any different decisions about property that was disposed of as part of that default. So to that extent, I would grant your motion, Mr. Isles, but I would say that with the caveat that there may be some evidence relating to that lot number 2 and how that all came about that may be relevant to the current claims. I don't know, and I won't know until we're actually in the presentation of evidence portion of this. So
I understand that, Your Honor. Quite frankly, more than anything, the objective of the motion was to make both yourself and Ms. Hayes aware of the issues so that you would have an opportunity to be on top of what they are when it comes time to decide, should I object to anything?
Right.
A few minutes here may save a lot of time on the 14th.
Understood. So, all
So
right, so
you're-
that's it. Go ahead, Ms. Hayes.
So Your Honor, what you're saying is we cannot enter in partial to in the trial as evidence?
Well, I mean, I don't know exactly. All I can say is, because I don't have everything in front of me right now, and I didn't get judges' copies of the motion or the response. So I haven't had a chance to look in detail at the deeds and things that were submitted along with those. So, but what I'm saying, Ms. Hayes, as a general legal proposition, is once a default judgment has been entered and a motion to set aside has been denied and there's been no appeal, then that any issues relating to that are decided and can't be changed. So to the extent that what you're asking me to do with lot 2 would conflict with that default judgment or change it, or to the extent that you want to offer evidence at the trial to change something about that default judgment, then I'm likely going to grant an objection by Mr. Isles to the presentation of that because I just can't change it. So presenting evidence about it is not relevant.
Your Honor, I'm going to look into, I thought I sent you a judge's copy of my motion with exhibits. I'll check into that. I'm surprised to hear that today. So I apologize.
It's in the file, and so is Ms. Hayes' response, but I didn't get judge's copy, so I was able to read it at lunchtime quickly, but that was it. So
it may have been my oversight, but I honestly thought that I'm trying to remember whether I mailed it or emailed it to Jen, but I'll find out what happened. And again, mea culpa, I'm sorry that you did not receive it.
all right, so that's all I have for this hearing today. We'll proceed further as scheduled on July 14th, and you're free to disconnect. Thank you.
Thank you, Your Honor. Have a good day. I cannot turn.
All right, looks like we have everybody connected, so we'll go on the record in the entire matter. This is file number 2213998. And if I could have all counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Judge Emily Peacock for the plaintiff.
Good afternoon, Your Honor. Sandra Lake on behalf of Mr. Shullock, Dr. Craven, and Kalkaska Memorial.
Patricia Shabath, Judge on behalf of Dr. Szymanski and Northwestern Michigan Emergency Physicians.
Okay, thank you. We're on the record today. We've got a number of motions in limine that are set for hearing. So I've had a chance to review a few of them. Some of them, I'm continuing to get responses and filings. So there are a couple, and I didn't get judges' copies of everything. So some of it, I think counsel's aware. I have 3 county circuits, so I'm in court here in Kalkaska, but my office is in Gaylord. So when things get filed in Kalkaska, unless I get a judge's copy, I don't see it until I'm actually in front of the physical file here, which didn't happen until today. Unfortunately, I'm a little bit unprepared on some of these issues because I haven't been able to read through the filings. So I guess what I'd like to do, number one, is there's a few that I think I can kind of address just out of hand. And so I'm going to do that, and then I'm going to consult with counsel and see where we're left, and what else is left. So, and these are all motions that were filed, I believe, by Ms. Lake's firm, but I believe concurred in by Ms. Shabath's firm.
I did file 2 motions also, Judge.
Right. And yours, Ms. Shabath, I think were relating to the expert testimony. Is that right?
Damage claims by experts, yes.
Yeah,
So
okay.
mine were related to life expectancy and household services.
Right. And Ms. Lake, your firm filed concurrences with those, right?
We did, Your Honor.
So those are the 2. Ms. Shabath, I did not get a chance to even see those until I got judges' copies of the concurrences, but I didn't get copies of your motions or Ms. Peacock, your response. So those are the ones that I think those are really the only ones that have any real meat to them, unfortunately. But let's get to that in a second. Let me address the other one. So we have a motion regarding, the anchoring issue. We've got a motion regarding the reptile theory issue. We've got motion regarding, just indicates concerning general trial matters. All 3 of those, I certainly appreciate counsel raising those issues. It puts me on notice that might be something that becomes an issue at trial. I frequently get those types of motions in limine prior in civil cases like this. And those are just issues that, to some extent, they're, when you hear it, you know it, or when you see it, kind of a thing. And so they're really difficult to rule on as a pretrial matter, and in my view, more appropriate to be ruled on at the time, depending on how, those things are presented and in what way. So as to those issues, I'm not going to make any rulings. Again, I appreciate counsel putting me on notice. I'll certainly be aware of defense counsel's concerns as well as plaintiff's concerns about their ability to present their case in the way they want to. You guys are all very experienced attorneys, and so we all know the rules and what's permissible in front of a jury and what's not. I know counsel is part of your job to get your toe right up to the edge of that line, and I understand that, but we'll have to find out where that line is, I think, at trial. So I'm not going to address those directly here today.
Judge, are those 3 denied without prejudice?
I'm just not ruling on them.
Okay, thank you. That's fine.
Yeah. I'm going to preserve those issues for trial and rule on them as needed, if needed, at the time of trial. Okay, so there's one more also, regarding the admission of the written expert reports. There was a motion in limine to preclude that. Again, I think that's really a game time kind of decision, depending on when it's presented, if ever, and what the context is and the purpose for offering it. So again, that's another one that the court is not going to rule on. So then Ms. Lake, one of the ones that I did want to hear from counsel on is the use of video deposition testimony, that motion. And I think that objection or motion pertains to the use of that pre-trial in the opening statements and then in the closings. Is there anything else you wanted to indicate on that one?
Well, in reviewing plaintiff's response, it looks like plaintiff is agreeing to that as long as we also will not present video in the opening statements. So I think the way I read it, and Ms. Peacock can confirm, but I think we are in agreement on that one.
I'm not sure about that, Judge. I agree not to use them in opening statements. Of course, there are certain court rules that would allow videos to be played if there was an inconsistent statement, just like as usual. But I think just like you've ruled on all the other motions here, that's kind of a game time decision.
All right. I mean, I generally agree that in terms of the opening statement, I think I would preclude that as part of an opening statement. I think, for closings or, if that comes into evidence or that testimony comes into evidence, certainly it could be played as part of a closing and may be appropriate. So I guess on that one, Ms. Lake, I would grant your motion to the extent that it wouldn't be permitted as part of an opening statement. And then the remainder of the court, that's what the other motions would simply reserve ruling on until the time of trial.
And I can prepare an order.
Yeah, and then the next one was with regard to hearsay testimony, and I think that primarily encompasses testimony by one or both of the plaintiffs about things that they were told by medical personnel and the doctors and so forth. And I don't know, again, that's another one I didn't have a chance to see the responses on. So Ms. Peacock, what's your position on that one?
Yeah, I mean, it's just two particular statements by Dr. Cleffellow, who is the neurosurgeon in the case. These statements that he made to Mr. Antaya are remarkably similar to what's in his medical record, to the extent that Mr. Antaya would testify about those statements. They're not for the truth of the matter asserted, but for the effect on the listener. He essentially told Mr. Antaya that if he didn't do surgery that night, his wife would die. So that's not being introduced for the truth of the matter asserted.
All right, Ms. Lake, anything you wanted to add?
Yes, Your Honor. That's not the statement I was concerned about. What I'm concerned about is that Mr. Antaya testified that Dr. Slufo told him that they had waited too long, basically suggesting that this patient should have gotten to surgery sooner. That statement could be easily misconstrued by the jury as a statement with respect to standard of care. And that's important because my doctor is an emergency room doctor. Dr. Slufo is a neurosurgeon. So he does not qualify to give standard of care testimony. The other thing, Your Honor, is that Dr. Slufo, I fully anticipate will be testifying in this case. And so to the extent, I guess plaintiff wanted to try to ask Dr. Slufo about that opinion. Plaintiff will certainly have the opportunity to do it without it being a hearsay statement.
And I mean, I think, Judge, the waiting too long also goes to causation in this case. Time is spine. The longer that they had to wait, that's not a standard of care opinion. That's a causation opinion. To the extent at the end of the trial, you feel that the jury would be confused about that, that's a limiting instruction. It doesn't preclude the evidence from coming in.
All right. Well, I guess I thought this was one that I might be able to parse out ahead of time. But again, I think this is like the others, depending on what statements they are, the context, and of course, the purpose for which it's being offered. Now that we're talking about this and I'm hearing from counsel, again, I think this is going to be one that I would have to rule on at the time that those statements are offered, because because Ms. Lake, I kind of see your point of view here, even if they're not offered for the truth, there's still 403 considerations here. And if it's going to be a statement that's confusing the jury, then even if it's offered for a proper purpose and not hearsay, it still may be excludable, depending on, again, exactly what the statement is. But, if it's that close, the court can also give a limiting instruction to the jury and explain that, and that could cure the 403 issue. So again, I think it's going to be highly situationally dependent. And so I don't think it'd be fair to either side to either permit or exclude that as a blanket ruling here now. So I'm going to add that to the issues.
Sorry, I was just trying to make those the court, or you could.
Okay. That was good. Is there any way you can wait till a little bit? I'm like really in the middle of it.
I'm sorry.
Yeah, I'm sorry. I don't want to stop them from doing it, but it's going to be distracting and not fair to my litigants. Sorry.
Everybody's got a job to do.
Like, we're in the middle of a hearing. Like, come on. Anyway, sorry. Neither here nor there. Okay. So anyway, we're going to add that. So I think that takes care of the other issues, all those ones that I can't rule on. And so then I guess what I'd like to do then, Ms. Shabath, is move on to your motions. And what I'm going to do is have counsel present their arguments here, and I'm going to have to rule on these later, because again, I think these have a little more meat to them, and I think I really need to take a look at the filings that parties have made. So, but I'd like to preserve the oral argument. So, Ms. Shabath, if you'd like to go forward, please.
Yeah, yes, thank you, Judge. I'll start with the motion in limine that relates to life expectancy. So in this case, there was agreement among the life care planner for the plaintiff and the life care planner for the defendant that the plaintiff's life expectancy was based on a table that related specifically to spinal cord injuries. And so they both agreed that it was 7 years or in the neighborhood of 7 years. And the testimony was taken at different times, so it might be 6 years now if it's a year later. But essentially, the argument from the defense is where you have a specific table that directly applies to the injuries at issue in the case, and plaintiff's life care planning expert has indicated that is the basis for their determination, then you can't have what we have here is separately then their economist used 16 years of life expectancy in his calculations as to the length of time the damages would apply. And so plaintiff's response suggests that this is no different than seeking to admit the U.S. life care tables, and there's exceptions for the reasons that those should get in. And they cite a case where they cite the case of Rickwalt and claim that it is for the proposition that the appropriate thing to do is to let all of the evidence go to the jury and the jury sort it out. So you let in the life care planning testimony from each side that says it's 7 years, and then you also let in the economist testimony that says it's 16 years, and you let the jury figure it out. Well, that's not, in my view, what Rickwalt stands for. And, plaintiff pointed out Rickwalt wasn't cited in our brief. Well, we weren't arguing about the life care tables in the abstract. We were arguing that in this case, where there is a specific injury to a patient, and that specific injury results in a different life expectancy that is agreed upon by experts in that field, that is a different situation than simply having a plaintiff ask the court to take judicial notice of the life care tables or citing the potential hearsay exceptions to the life care tables. This is a 702 argument. This is an argument that says there is not a sufficient factual foundation for the economist to rely on a 16-year life expectancy where there is a more specific and more applicable table that has been adopted by the experts in that field, life care planning, for both the plaintiff and defense. So there is some case law out there. Again, we didn't brief this as a do the life expectancy tables get in or not, but there is some case law out there that essentially suggests that, and the case law, I will be candid with the court, it more relates to when this was a standard jury instruction, the life care tables, and they've since been, removed from that. So some of the case law suggested, look, if it's in the standard jury instructions and someone asks for it and it applies, it gets in. But there were circumstances where courts would say, no, we're not going to let that in. We're not going to give that instruction because in this case, there has been evidence that the plaintiff's life expectancy was diminished and there was reliable medical testimony that the plaintiff's life expectancy was diminished, and the life care tables really only relate to or are applicable to healthy, generally healthy individuals. So there is some case law out there that says, while they may be admissible, if you have evidence to the contrary, it's not exclusive. They don't always get in. Here we have a different situation. We're not just arguing about, do the life care tables get in? Is there evidence against her having a normal life expectancy? We're saying very specifically, she has a spinal cord injury, and there is data that supports that there is a specific reduction in life expectancy that plaintiff's own expert has adopted. So there is no factual foundation for the economic expert to sort of throw all that out and say, well, I'm going to go with 16 because I'm going to go with the life care tables. So that's essentially the crux of the defense argument on this point on life expectancy.
All right, thank you. Ms. Lake, did you have anything to add?
I don't, Your Honor. Thank you.
Okay, Ms. Peacock?
Judge, this was thoroughly outlined in our brief. I apologize, our response brief. I'm sorry you did not receive it in time. In terms of Ms. Shabaz's argument, I do think that the life tables are standardly judicially noticed, and my economist is free to rely on them. I do believe there will be medical testimony that the life tables take all comers in terms of life expectancy, those people with spinal injuries and those that do not. And that is a question for the jury to take all the evidence, medical evidence that is given and decide what the plaintiff's life expectancy will be. So I would ask that the motion be denied.
Judge, could I just add one more point? I
Yes.
apologize. So this goes back to a 403 issue that the court was just mentioning in a different context. I think if you let both the life care tables in and the specific spinal cord injury data in, it certainly raises the specter of confusing the jury and giving them conflicting information and arguably inaccurate information. I don't think there's any dispute in the case that having a spinal cord injury reduces life expectancy. So why in the world would we knowingly submit to the jury data that is inconsistent with that and also inconsistent with what two of the experts in the case are going to testify to? So I think it does, the notion of let it all in, I think that does run afoul of 403 as far as confusing the jury needlessly. And for that's an independent reason I think it should be excluded.
Judge, can I address that since it wasn't in her brief?
Yeah, absolutely.
Judge, in terms of life expectancy, there is often different testimony, and there are unfortunately, way more than two experts in this case. And all the experts in this case have different opinions. That's why we are going to trial, and the jury is the decider of fact in this case. And this is an issue for the jury to decide, given properly introduced medical evidence regarding life expectancy.
Okay. All right, thank you. And then Ms. Shabath, your second motion regarding I think it was duplicative household services claims.
Yes, so this relates to the testimony and reports from plaintiff's life care planning expert and economic expert. Again, same issue, different nuance to it. So in the plaintiff's life care plan, they include reference, their argument is that they need a home health aide 24/7. And that home health aide is going to perform certain services. Even within the plaintiff's experts' reports, those services are contemplated to include cleaning and cooking and other household related items. And then you have an economist, again, who then issues a report that references loss of household services and says the household services that Ms. Antaya otherwise would have provided, but for her injuries, such as cooking, cleaning, doing things around the house. So the defense position is that violates the prohibition on double recovery. And we cite in our brief the case law that supports that. But if you are having two different experts comment on compensation to the plaintiff, but it's referencing the same services, then it is duplicative. And so in plaintiff's brief, they say, no, you don't understand. This is compensating Ms. Antaya for the injuries that she can no longer perform, meaning self-care and the ability to take care of herself. And then it is separately contemplating Mr. Antaya, who is also a plaintiff, for the loss of his wife's services to the household. But if what you really look at is the reports and what it is that they are contemplating as part of those services, you find that it is duplicative. They're counting the same thing. So I don't think there's going to be a dispute in the case because it's in their report that home health aides also provide cleaning services and other things that are contemplated by the same damages that are addressed in the loss of household services. So it's not just, you're not having a home health aide who's going to, for example, help Ms. Antaya, toilet and get cleaned up and move around the living quarters and then just sit around and do nothing else. If they're going to be there 24/7, I think all of the experts agree that the services to be done, that the job description of a home health aide includes such things that are contemplated by the same services that Dr. Vanderlyn says would be contemplated by household services that would have been provided for Ms. Antaya. So even though they're characterizing them as separate experts, separate plaintiffs, separate damages, if you look at the actual services being provided, they're the same. And if you look at the reports of the experts that describe the services being provided, they're the same. And for that reason, it does violate the double recovery. And what we're asking the court to do is exclude the economist's damages that relate to loss of household services because they are already contemplated by the life care plan.
Okay, thank you. Ms. Peacock?
Again, another very specific motion on what may or may not be testified at the time of trial, addressing the double recovery. Yes, Miss Antaya undoubtedly needs 24/7 care and someone helping her at all times. Mr. Antaya is a plaintiff in the case. He no longer has her help with cooking, cleaning, laundry, shopping, all those things. Actually, the poor man now does for both of them himself, separate losses. I don't think there's a double recovery here. We're talking about having someone do some heavy cleaning in the plan from the economist. I think it's different things, and they can talk about that when they testify at trial, Your Honor.
Okay. Ms. Lake, I left you out. Was there anything you wanted to add to the defendant's argument there?
No, Your Honor, thank you.
Okay. Okay, I think I've got the positions of the parties, so I'm gonna rule on those two motions as quickly as I can following this hearing. I am just gonna ask Ms. Shabath and Ms. Peacock if you can both today just send additional electronic copies to Jennifer, to my assistant, of on these two motions only. Ms. Shabath of your motion and Ms. Peacock of your response, and any attachments that you have, if you can send those electronically too.
Will do, Your Honor. And again, like Ms. Peacock, I apologize that the court didn't get those. But sometimes it's hard to get everybody on the same page as far as the 3-county circuit and where they have to go. And so while the primary lawyers on the case may know that, not everybody does, and that's our failing, and I apologize.
Okay. All right. The only other thing that I want to mention, because I think we did not talk about this, to my memory, when we had our trial prep conference in May, and I'm not sure if council's aware or not, but June 19th, which is the Friday kind of in the middle of our 2-week trial, is now a holiday. So as much as I don't want to take up a date, in the middle of a trial like that, we are going to have the court closed on that day. So I just want all of you to be prepared in terms of, having your witnesses available and stuff. I just still want you to subpoena people for the 19th when we won't be able to have court. So I'm sure you are aware of that, but just in case, I wanted to highlight that.
Judge, just so you know, you mentioned that when we scheduled the trial a long, long time ago.
Good. Thank you. Again, with 3 counties and
I wasn't in the case then, so it's news to me, and I appreciate the knowledge.
Okay. All right. That's all I have for today then. Thank you, and all parties are free to disconnect at this time.
Thank you, Judge.
Thank you. Have a good day.
Bye-bye.